Okay, hello all. Thank you for bearing with us for our technical difficulties that we're having. We appreciate that. Welcome to the National Center on Criminal Justice and Disability webinar. My name is Ashley Brompton, and I am the Criminal Justice Fellow here at NCCJD. So we're going to go ahead and get started. Unfortunately, I think our first presenter is not going to have video due to some technical difficulties, but participants are in listen-only mode. If you need help during the presentation, you can post questions in the chat box on the side of your screen, and we'll be sure to help you. At the end of the session, there will be a time for questions. So during the presentation, or after, you can either post questions in the Q&A section or the chat box. If you don't want your name shared with your question, please type private before your question. You can also email questions to ncccjdinfo@thearc.org. And if we don't have time to get to your question during the presentation, we will follow up with you afterward. The webinar is being recorded and will be posted to our website. We have just one final request. You will receive a session evaluation after the webinar. Please take 5 minutes to complete it and submit it. It really helps us gather up the information we need to continue these webinars. And this webinar is funded by the United States Department of Justice, Bureau of Justice Assistance. We want to thank our two panelists today, Steve Gordo, who's a parent advocate, and Elizabeth Kelley, a criminal defense attorney and board member of the National Association of Criminal Defense Lawyers. And thank you all for your participation. Our first presentation today will be from Steve Gordo. Steve is a father and retired school teacher from Monterey County, California. He taught in public schools for over 18 years, including 7 years of teaching special education. His 18-year-old son, Paul, has autism. Steve has become a passionate advocate for the inclusion of people with disabilities and maintains a Facebook group and other social media efforts. The change.org petition he created on behalf of his son had nearly 13,000 supporters nationwide. Even though Paul's case has been resolved, Steve continues to advocate for others like his son and maintains a burning passion for the issue of justice for people with autism and other related disabilities. Before I turn it over to Steve, just one quick programming note. We all wanted Paul Gordo, Steve's son, to join us today as well, but unfortunately he's unable to do so. As part of his probation, he's at a residential center in Kansas and unable to have access to telephone and the computer for this webinar. NCCJD generally strives to ensure that self-advocates like Paul are a part of the conversation as much as possible, and we did try to have him here with us today, unfortunately, without success. I'm now going to pass it over to Steve, and Steve, you should be good to go, other than we don't see you, unfortunately, but you should be good.
Well, thank you, Ashley, and I want to thank everybody that's listening, and those of you that may listen in the future. I want you to know that Paul is a very complex person, and a lot of people, if you were to, if he were here right now, he'd be asking many of you where you went to college. He might ask you what your favorite amusement park is. He's got a burning curiosity, but he's always trying to figure out what matters to other people. I think that is an undying characteristic with Paul, is he always wants to know what other people are thinking, which is, I don't know how much people know about autism, but that's right at the core of what most scientists would tell you about autism, is that there is a sort of a confusion about theory of mind, about what other people might be thinking, very hard to read body language. Temple Grandin described it as trying to be an anthropologist on the moon. There's kind of a physiological disconnect that makes it really hard for some people with autism to communicate their thoughts, and even more importantly, understand the thoughts and feelings of others. So anyway, I want to thank everybody for being here, and you would love Paul if you got to meet him. He's a complicated guy. It doesn't mean that he's always a happy guy. He would like to be a hero, but there are times when he can be pretty grumpy, and that's kind of how he got into trouble with the justice system. There are a couple of pictures of Paul. One is more recent, about within the last 2 years. The one on the left. The one on the right is when he was probably about 12 or 13, maybe even 11 years old. Paul has autism. He was diagnosed at the age of 4. He has been in special education since that time. Paul is considered high functioning, but for many reasons has not yet acquired the social skills he needs to realize his potential. Paul is supposed to receive home and hospital instruction from a local school district. In July of 2015, the school district suggested Paul meet with an instructor at the local library. We set a time and a date. Local library might be an appropriate setting if a student is doing independent study. But for a home and hospital student, it's called home and hospital for the very reason that there is some medical reason why, or typically a medical reason why that person needs to be taught or instructed in the home or at the hospital. The school district hadn't provided the home and hospital instruction he was supposed to have for about a 3-month period. So we kept nagging. In the meantime, they were looking for a residential placement like Lake Mary, and this is back in July of 2015. I delivered Paul to the library, met an instructor new to Paul, so this was a brand new instructor meeting in the library, and I was fearful that the instructor may not quite be prepared for Paul and his special needs. So I decided to stay in the library while the teacher instructed him. After about 50 minutes, Paul was showing signs of being restless and agitated. The instructor asked my advice. I told him it was up to him whether or not to discontinue instruction. Meanwhile, Paul went to the restroom. Paul returned from the restroom, speaking in a loud voice. His teacher indicated he needed to be quiet, and I reaffirmed this. To be honest, I was concerned because one of the triggers for Paul is being told what to do. When he's agitated, he likes to be given escape options rather than being told, hey, well, you need to do this. So I was concerned that he was going to start excuse me, becoming physically aggressive with his instructor. So I went ahead and reaffirmed. I did the classic and put my index finger to my lip, hoping that any anger that he would have, he would direct it at me rather than at the instructor. That was partially successful, but anyway, Paul yelled, and then he ran out through the exit door. And of course, he bumped a total of 3 people. As he ran past a man queued at the checkout counter, he pushed that man's shoulder. The man took a step, but quickly recovered. As Paul neared the exit door, he pushed another man who bumped into the nearby wall. Finally, he exited the doors. He made a path for a car, but an older woman was in the way. He extended his hands, pushed the older woman. She fell flat on her back. As fate would have it, that woman was especially vulnerable as she had Huntington's disease. She did have a cane, but it wasn't really apparent how frail she was until she was unable to break her fall. As it turned out, she was unconscious for less than 1 minute, and after being seen at a hospital, was diagnosed with having suffered a mild concussion. I'm not trying to minimize the damage. There should have been no damage to this woman, but if you know the story, Paul ended up being charged with a felony for this event when this, a 5-year-old could have pushed this woman down with the same force that Paul used. Paul stopped immediately. He was still agitated from escaping the library, but he seemed to be shocked that the woman fell. The woman laid still and apparently unconscious. Not long after Paul apologized, but neither the woman nor the husband could hear him. The woman's husband rushed at Paul as though he meant to hit him. I honestly thought that's what was going to happen. The man was very upset. He yelled that his wife had Huntington's disease, that Paul was a, quote, thing, and, quote, animal, and that Paul should go to jail. After 15 to 20 seconds of yelling at and about Paul, he finally tended to his wife. I personally felt like I died that day. I was every bit and more angry at Paul as the woman's husband was. I was filled with fear and dread. I feared for the woman. I feared for Paul. I took him to the side and I waited for the police. The local police already knew Paul from calls we had made when Paul was acting out at home. The police proceeded with taking statements and interviewing Paul. One officer's report insisted that my statement was that Paul had tackled the woman, and he almost insisted on those words, and that is not true. Paul pushed her as though pushing her out of the way. During the police interview, an officer asked him if he knew what he did was wrong. Paul said yes. The police reaffirmed that Paul had autism and sent him to a local psych ward under a 5150. I don't know if that's a nationwide code, legal statute or whatever, but danger to self or others, and for a observation by a psychological ward. I'm grateful they chose this over jail. I've learned since then that there are places where someone under these circumstances with autism, behaving impulsively, could still be sent to jail where there's absolutely no therapeutic services or interventions available, not to mention the predatory environment that jail would pose for somebody with autism. I'm grateful they chose this. Paul was released the next day. The consequences. The law is a donkey. The crime occurred July 2015. By September 2015, we had heard nothing from the authorities until Paul received a notice to appear, and that's what I have pasted in up here is just the actual penal code with which he was charged from the Monterey County District Attorney's Office. I contacted the Assistant District Attorney, who explained that people are responsible for their actions regardless of their disability. I was really quite shocked that they were proceeding with a criminal case. Paul was not only charged with assault and battery, it was later explained to me that these were felony counts and subject to California's three strikes law. Paul was on home and hospital because of these same aggressive behaviors, including pushing people. So behaviors that Paul will use to escape an unwanted task. These behaviors were well documented as a manifestation of Paul's disability. And this is where I make the contention that you're essentially charging someone with a crime for having autism. Because basically, the behavior is a direct result or a manifestation of his disability. What I've learned since then is that there is no coordination between diagnoses that occur within therapeutic or educational environments versus descriptions or accountabilities that are part of the law itself. I guess, quote, justice is blind, right? Well, to me, the law is a donkey. There's another word for that, too. It starts with an A. The attorney, we need a hero. So this is where we're in this bizarre area where we need somebody that understands criminal defense, but also understands special needs. So number one, we had never hired a criminal defense attorney before, so we have no idea where to turn to, how it works. I'm sort of in a panic, so I probably could have done a little more research with some local advocacy groups. I did not know that ARC had the Criminal Justice Division or group here, or the National Center on Criminal Justice and Disability. I probably could have referred to them. But again, at the time, you know, how much experience would most people have with this? So two, I need to find an attorney who has A, criminal defense experience, B, knows about developmental disabilities, C, knows the nuances of criminal defense for someone with a developmental disability, and D, has all of the above. So three, where do I look? Yelp. My long list of friends with disabilities who have hired private attorneys for criminal defense. Most of the time in the past, including at school, when Paul had pushed someone or something like this that could be described as an assault, technically, there was, you know, apologies, there was profuse understanding, and people stepped away and said, oh, yeah, it's okay. Of course, he had never really hurt anybody to any degree or seriously. Well, actually, I take that back. He had hurt people in the past, but no criminal charges had been made, and the people that he hurt were staff members at school. So I take that back. So again, do you go with a local attorney or do you go with somebody that has a specialty? As it turned out, I ended up, based on a recommendation from a friend who was an attorney, I retained an out-of-town attorney. It was not cheap, but we weren't interested in being, you know, saving money at this point. We were in a panic. Our first attorney was as shocked as we were to find out that this case was not being bargained out or summarily dropped. At arraignment, the ADA insisted that the case was going forward because there was a victim. So to me, and my argument is that at what point is this distinct from an actual crime where there's a mens rea, where there's an intent to cause harm versus like a traffic accident? You know, they have victims, but they're, you know, often not always a criminal case that comes out of those. We felt confident that this was one that once this was put before a judge and the mitigating facts of Paul's disability were coming into play, a reasonable and fair judge would press for, you know, either dropping the charges or press the DA to at least reduce the charges so they aren't so extreme. Once our first attorney met with the judge to see which Paul's case had been assigned, our dreams of reason winning out had left us. She insisted, number one, even though Paul had finally been accepted to a Kansas residential program, where he is now, that would address these very same behaviors, she exercised her discretion that Paul could not leave the state. Okay. Two, the only plea deal being offered was that we plead out to the felony charges as they were. So basically, I mean, I don't know who in the world would do that. Why would I plead out or have my son plead out to charges as they are if you're not offering any kind of step back or any kind of deal that's to his advantage? And then he could go to the Kansas program under probation. The judge recommended no changes to this offer. So basically, we were wrong. Reason did not win out, and I am still stunned by that. We learned that the judge had been a prosecutor for 14 years, and it became clear that our position was not being appreciated. And in my judgment, it was like having two prosecutors on one case. The judge was absolutely no help to getting Paul his needed help, and I can't help but reserve some anger about that. The locals have the inside track still. Our attorney is an ace, but Small county politics had enabled the DA's office to maneuver the case into a decidedly unfavorable courtroom, and by the time our attorney realized it, he was from out of town, so we didn't really know the local politics of the court. It was too late to ask for change. So dreams of reason dash, I began a 10-hour per day social media campaign, which Ashley already mentioned. The change.org petition was just one of many things that I engaged in. Reaching out to support groups, we had gathered several letters of support, including a profoundly well-reasoned letter from Jill Escher of the Autism Society of America. By the way, that is the first autism advocacy society in the United States, and I can't say enough good things about Jill and her local chapter that were really helpful to me. Our attorney forwarded several psychological reports, conservatorship forms, and a copy of that excellent letter from Jill Escher, and still we got nothing. First of all, I think, and I'm going to start summarizing because I can see that I'm kind of running out of time, but this ADA really is a layman to all the material we're providing him. I don't even think he bothered reading it because, I don't know, I don't want to say that he didn't care. I mean, he doesn't seem like he's a bad guy. Neither he nor the judge seem like really bad people. It's just like they were already quite certain that this should go forward, that everybody's accountable and it doesn't matter what your disability is. And to be honest, I think that most families would not be fighting. They would just be apologizing and pleading to whatever the DA handed to them. And that's the problem, is that there are nuances to this that need to be understood. So I already told you about my media campaign, storming the wall, we'll call it that. I'm going to skip forward here. Again, we did get a little bit of a better of a deal, and that was basically plead to a non-strike felony. We said no to that, and that's when the DA's office added a misdemeanor for another one of the other people that Paul had pushed that day, even though there was no injury. Hard facts. Our first lawyer basically told us, well, you know, you may want to go ahead and plead to this lesser felony because there is a 10% chance that Paul could end up in prison. Okay, we weren't having that, and that's when we went ahead and sought out a local attorney with a great reputation. That's his picture. I'm on page 24 here. That evening, we retained a well-known local criminal defense attorney, and he was really encountering the same wall, but he started doing a lot of homework, and I think his efforts are what really kind of made the difference here. Both of our attorneys had basically came up to the same wall of resistance, but Tom Worthington decided to go ahead and emphasize a forensic psychologist report, and we proceeded forward with that. And he did a tremendous amount of work, well beyond the hourly of his retainer. So the second Tom Worthington of Salinas, I already told you about the psychologist report. I'm on page 26, and that's a picture of Paul with a different psychologist. That would be Lucy Van Pelt. He did not get she did not write a report for this. All three charges were reduced to a misdemeanor, to one misdemeanor assault causing great bodily harm, which, again, great bodily harm was another bone of contention. Okay, how long does somebody have to be unconscious for it to be great bodily harm? And in the end, we felt like even though we could win at trial, we felt the trial could be another 6 months, and that's another 6 months that Paul would not be at the therapeutic facility where he really needed to be. So we kind of felt pressured to take this new deal so he could go to Kansas. Is this justice? Well, I'm going to let you read that for yourself. The big problem is, who do you call? I almost feel like there should be a mental health court ombudsman liaison available for people with disabilities, because, I mean, if every person with a disability that pushed someone and that person fell down was put on criminal trial, then, you know, the courts would be full all day. Out of Oz, back to Kansas. Paul's condition is not obvious. I cannot help but feel that this would not have been a problem for a DA if Paul was more obviously disabled. See, that's one of the insidious things about autism. It's called an invisible disability. There are forms of mental illness that kind of be that, but they are two different things, by the way. But because of this experience, Paul missed over 3 months of therapy. He was approved for admission to Lake Mary in Kansas in November, but he did not end up going there until late February, early March, because of this court ordeal. He does not trust law enforcement now, and he was actually obsessing, imagining that he would be tortured for his crimes. Lake Mary has been great. He's making great progress. We're going to be seeing him. Paul was prosecuted for something that was an established problem, and the local library was not appropriate. And so he can't vote, but he was held to be responsible for his disability, even though other people had decided that he would be there with this known problem. He would be there in this environment where harm could happen. So my closing thought is that Mr. Bumble, a cruel head of a workhouse and Dickens Oliver's twist, declared that the law is an ass. But should we too be such? And those are my hashtag search, whatever it is you call those things, and then our Facebook page. I thank you so much for listening, and I'll stand by for questions.
Great. Thank you so much, Steve. We appreciate it. Again, we wish Paul could have been here, and we understand that he couldn't be, and we appreciate you really giving us some insight into Paul as well. So our next presenter is Elizabeth Kelley, and she is a criminal defense lawyer based in Spokane, Washington. She travels throughout the country working on cases involving people with mental illness and intellectual and developmental disabilities. She is serving her third term on the board of the National Association of Criminal Defense Lawyers, chairs its mental health committee, has chaired the membership committee, and is a life member. She has served on the problem-solving courts task force and currently serves on the body camera task force. In 2009 and 2014, she traveled to Liberia as part of a mission. She traveled to Liberia as part of a mission sponsored by the NACDL and the UN Commission on Drugs and Crime to train the country's criminal defense bar. In 2013, she traveled to Cuba as part of a people-to-people delegation for lawyers and judges. In 2015, she led a legal delegation to London and will lead another delegation to India in 2016. She lectures across the U.S. on representing persons with mental disabilities and frequently provides legal commentary for radio and television. Her book reviews regularly appear on The Federal Lawyer, and she hosts 2 internet radio shows, one titled Celebrity Court, and the other is entitled Author Chats. And here is Elizabeth Kelley. If you can hear her, hold on 1 minute, Elizabeth, you're muted.
Can you hear me?
Yes, we can. Go ahead. Uh-oh.
Hello?
There you go. You're good.
Can you hear me?
Yes, we can.
I feel like a Verizon commercial. Good morning or good afternoon to all of you on the East Coast. and thank you for this opportunity to speak with all of you. Last night, I was thinking about my remarks, and I was very concerned because usually I just speak with lawyers or I just speak with parents and families and other advocates. I've never spoken to such a mixed audience before, and I was concerned that if I directed my comments towards one portion of the audience, the other might feel left out and neglected. And then I realized that that was not really a valid fear for a couple of reasons. First of all, although we all come to the table from different perspectives, we both want the best for our loved one, or in the case of lawyers, the client who is charged with a crime, notwithstanding his or her mental disabilities. And the second thing that both constituencies have in common is we, sad to say, are used to dealing with people who are profoundly misunderstood. Certainly parents and families have experienced a lifetime of having their loved one with mental disabilities shunned by schools, neighborhoods, friends, churches, employers, and sometimes the legal system. And we as criminal defense lawyers deal with people who are accused, rightfully or wrongfully, of some of the most heinous crimes you can imagine. And in the case of people with mental disabilities, as Steve so well described, they are not just misunderstood, they're often demonized, and they scare people. They scare law enforcement, they scare prosecutors, they scare judges, they scare jurors. So with all that in mind, what I'd like to do is comment on a number of things that Steve said, and then certainly at the end of this session, I'm happy to answer any questions or concerns that people might have. First of all, both in the beginning as well as at the end of his remarks, Steve talked about how Paul is very high functioning. In fact, at the very end, he called autism an invisible illness. And this leads to a huge challenge for us as criminal defense lawyers, because so often we are before court, and the court assumes, well, if so-and-so has a driver's license or graduated from high school or holds a job or has an impressive memory, he or she can't possibly have a mental disability. And it's up to us as counsel to paint a picture for the court that, yes, although someone did graduate from high school, he or she was in special ed classes, or although he or she holds a job, it is a very mechanical type of job, and if there are any changes in the workplace, those changes have to be explained very slowly and very deliberately to the person in order for him to be able, or her to be able to make the change. People with autism often spend a good deal of time on the computer. In fact, that is their social network. And unfortunately, sites like Facebook can be a huge trap for people with autism, and we need to explain to the court that one of the reasons why they spend so much online is not because they're trolling, not because they're sexual predators, but this is perhaps their only social outlet. The next point I want to touch upon is the interview that Paul had, where unfortunately he confessed to the crime. Now, as the lawyers in the group know, there is still shamefully in our country a high rate of forced confessions, and the population which is most vulnerable for giving false confessions are people with mental disabilities. And even, well, if there were a do-over in this case, and Steve and his wife did a wonderful, beautiful job of advocating their son and protecting for their son. But if there was any deficiency in this case, it was the fact that Paul, as I understand, and Steve, feel free to correct me, Paul did not have counsel at the time of that interview. Paul should never have spoken to law enforcement, and law enforcement should have known better, because people with mental disabilities are often very eager to please authority figures and also can't always weigh the consequences of their words. Another point I want to touch upon is the attitude of the judge and the district attorney's office in this particular case. As Steve said, these are not bad people, but unfortunately there are a couple of things about them that we as advocates for people with mental disabilities should be acutely aware of. Number one, by and large, they are elected officials. No judge wants to run for re-election against an opponent who has painted him or her as being soft on crime. Certainly no district attorney wants the reputation that his or her office is soft on crime or coddles criminals. And I don't know if there was any media coverage of this particular incident, but quite often that plays into the equation. And also make no mistake about the fact you had a victim in this case. And it sounds as if her husband and she were both pressing for the most serious charges possible and the most serious penalty possible. And in most jurisdictions, the district attorney's office has to run by the victim any plea offer that might be extended. And if the victim does not sign off, if the victim does not agree to the plea offer, it cannot be tendered. The second important thing to remember about judges and prosecutors is that they don't know a lot about mental disabilities. And for 1,000 different reasons, I always cringe when there is what we call a rampage shooting, like Aurora or Sandy Hook, because the thing that the media latches onto is that the alleged perpetrator has some type of mental disability. And this causes prosecutors, this causes judges to jump to the conclusion that people with mental disabilities are inherently dangerous. And it is our job as counsel to point out to them that if people with mental disabilities, like Paul, have the proper structure in their lives, if they have proper supervision, if they have proper treatment, if needed, if they have proper medication, they are not a danger to themselves or to others. Another point that Steve raised is one that I pointed out in the Guide to Families, which I have done for the ARC and I know is part of the slides. And that is, medical terms do not equal legal terms. So, for instance, when you have someone like Paul who has autism, he doesn't have a mental illness per se, but the criminal justice system in most jurisdictions doesn't recognize that type of nuance. So, for instance, an attorney representing Paul, maybe not in someone like Paul, maybe not in this case, but in another case, could recommend a plea of not guilty by reason of insanity. And that would be the legal vehicle whereby Paul could not stand trial for the accusations. But he's not insane. But nonetheless, that's the legal vehicle that there is. And the other plea that could be given in a case for someone like Paul, or a plea that could be tried before a judge or a jury, is not guilty by reason of insanity. Again, that does not cover autism, that doesn't cover people with mental retardation, that doesn't cover people with fetal alcohol syndrome, but again, it's the terminology that we have. And Ashley, how many more minutes do I have? I've lost track.
You have about 20, so you're good.
I have 20 minutes left?
You do.
Oh, beautiful. Okay. Another point that Steve raised was the dilemma between entering a plea and going to trial. And this is an ethical dilemma that we as criminal defense lawyers face all the time with virtually all of our clients, and in particular, we face it with people with mental disabilities. For the lawyers in the audience, there is a law review article which I commend to your attention, and if you want to send me an email afterwards, I'm happy to forward it to you. It is called Candor and Zeal. It was published a number of years ago in the American University Law Review, and it is written by a law professor by the name of Jack D. King. Mr. King, for many years, was a public defender in Washington, D.C., and he gets it. That is to say, he knows that sometimes, for instance, if an attorney on behalf of a client enters a plea of incompetent to stand trial or not guilty by reason of insanity, that client may end up spending many more weeks, months, years, perhaps even decades in an institution being restored to competency than he or she would if he or she served even the maximum amount on the original charges. Mr. King raises a very interesting point, and if you go into the slides that I've submitted, you can see that attorneys have very important ethical principles which we are duty-bound to follow. And often we have the competing ethical strictures of candor towards the tribunal versus zeal. And at bottom, Mr. King comes down on the side of zeal. That is to say, it is our duty, absolutely, to be a zealous advocate on behalf of our client. But nonetheless, he is very sensitive to the different nuances, and in particular, understanding that sometimes what can and should be done in the case of a misdemeanor is very different than what can and should be done in the case of a felony like Paul was charged with. Another point that Steve raised was his tremendously powerful social media campaign, an extraordinary social media campaign. If, again, you go to the family guide that I authored, one of the points I raise is families should be very, very circumspect about recommending to the lawyer that the lawyer should, quote unquote, take this case to the media. And the reason why I say that is first of all, in many jurisdictions, although I have not presented a slide on this, there are very strict guidelines, very, very strict prohibitions about what a lawyer can say to the media. And in particular, outside of the ethical obligations, the family should be very sensitive to the fact that the media may not be your friend in this particular instance. The media may not understand the nature of the disability. The media could very much take the side of the victim, and the family could end up being in a media war with the victim and other advocates and supporters of the victim, and this could backfire. Another point that is very important is that of social media versus traditional media. And I have gotten so, and probably a lot of defenders in the audience have gotten to the point where they also advise the clients not to have any interaction with social media during the pendency of their case, and perhaps the family should not have any interaction with social media during the pendency of the case. First of all, important details about the defense might be inadvertently disclosed, and secondly, things could come up that could be used against the accused. So although what Steve did was powerful and effective, Steve was an extremely savvy user of social media, and social media as well as traditional media should be used very, very cautiously, if at all. Another point that Steve raised was the appearance of the DA not reading any of the materials that he submitted to the district attorney, and this unfortunately is often the case. So what I always do is put it in bite-sized pieces and not take for granted that the district attorney understands the nature of the disability. I do not let the district attorney, I do not let the judge make fun of my client's disability. And as obvious as that may sound, I have had prosecutors, I have had judges make fun of my clients. Thankfully not in open court, but in chambers and in other places. And this is absolutely inappropriate and inexcusable. Steve mentioned that his second counsel, or third counsel, I guess, recommended a wonderful forensic psychiatrist or psychologist who wrote a report on behalf of Paul. And the report can often be extremely important, not only in educating the district attorney, but also explaining the fact that it was because of the disability that the person in question committed the acts in question. Often this does not rise to the legal definition of not guilty by reason of insanity, but it can be used as mitigation of penalty. It can be used, as I gather was done here, to persuade the district attorney's office to back down from the original charges and offer something which is much more reasonable. The final point that Steve raised was that of mental health courts. And I know that Ashley is going to talk about those a little bit more, and I don't want to take away her remarks, but I would like to issue a brief cautionary note about mental health courts. They are present in most jurisdictions throughout the country. Unfortunately, they don't always cover felonies like this particular case. So Paul might not have been eligible. Also, make no mistake about the fact that in many jurisdictions, in order to participate in mental health courts, you basically waive your right to litigate pretrial issues. So, for instance, had Paul been eligible for a mental health court, he might not have been able to raise the issue of suppressing his confession. Also, you should be very sensitive to the fact that mental health courts are work. They're definitely work. And if someone is charged with a misdemeanor and your counsel knows or feels relatively certain based on his or her experience with this particular judge that the accused would only get a penalty of such and such versus 2 years, even 5 years on a mental health court docket, then you as family and advocates might want to strongly recommend that the accused go through the quote-unquote traditional docket. All of us as attorneys know that, unfortunately, the longer our clients are under court-ordered supervision, and it's not just with clients with mental disabilities, but all our clients, the more likely they are to trip up, inadvertently or not. They can't report to their probation officer. They may unfortunately use drugs or alcohol. They may pick up another offense, even a misdemeanor. All of these things can cause them to lapse. And a final point I want to raise, because I know I'm nearing the end of my time, is that of a lawyer's duty to protect client confidences. And it doesn't sound as if this was a particular issue in Paul's case, but it is in many, many cases involving people with mental disabilities. Very, very often, the person charged is an adult in the eyes of the law. However, families are extremely troubled by the fact that their counsel, their loved one's counsel, does not return calls, will not talk to them, does not seem interested, et cetera, et cetera, et cetera. And families should know that, number one, we as attorneys are bound to keep client confidences unless there is a written waiver executed by the client. And this is irrespective of the fact that the family is paying counsel if counsel is private. This is irrespective of the fact that for many years the family has been making the bulk of decisions on behalf of their loved one. Now, there are some nuances, and that is delved into at greater length in the ethical guideline for representing people with diminished capacity. And again, that's not my term, that's the term that the ABA model rules uses. But nonetheless, families should also be sensitive to the fact that many times the public defender's office is assigned to represent their loved one. And public defender's offices although they have wonderful resources, although they have wonderful attorneys, many of whom are very, very qualified to handle cases involving persons with mental disabilities, simply have huge dockets. And if they were to return every single family member's phone call, if they were to meet with every single family, then they would work even longer, more Herculean hours than they already work. Nonetheless, attorneys certainly can communicate with family in terms of sharing non-privileged information, such as when is an upcoming court date, what is going to handle or what is going to transpire during that particular proceeding, and the like. But nonetheless, as I always tell lawyers, families sometimes, if not always, have the best information about the accused and are very, very important in terms of assembling documentation, providing other information, providing the names and contact information of other people to interview about the specific nature of the accused final mental disability. And a final note that I do want to issue. Although we've talked a lot about plea bargains, although we've talked a bit about mental health courts, if this case is a triable case, that is to say, if there are a good set of facts and circumstances, by all means, this case should be tried within the spirit of the adversary system within which we as lawyers function. So as I said in the beginning, I'm happy to answer any questions or concerns that people might have towards the end.
Great, thank you so much, Elizabeth. We appreciate it. So I guess that brings me to a few last-minute things. So some tips for both attorneys and families to work together, some tips for both sides to be able to just really bridge that gap between families and clients and attorneys. So some tips for attorneys: identifying clients that have intellectual and developmental disabilities can be a challenge. A lot of times people with IDD will camouflage and don't want to readily admit or will deny that they have a disability. A lot of times they have a lot of ways to adapt so that they come across as fully functioning. As Elizabeth alluded to early on in her presentation, just because they've graduated high school or they have a driver's license or they work does not necessarily mean they don't have an intellectual or developmental disability. So some ways to identify it: look for an IEP, an individualized education plan in school, past psychological evaluations. If they've seen family history, get information from family, employment history. Another easy question to ask is, have you ever gotten Social Security disability or Social Security? That's an easy way. A lot of people don't necessarily associate that with admitting they have a disability, but they will tell you that they do get, or any kind of other services, Medicaid, things like that. Some easy ways. Some other signs that you can look out for. So if there's difficulty communicating, if you feel like you aren't really able to get your point across, do they seem responsive, able to understand the conversation, answer questions, things like that? Is there difficulty that you've noticed with reading and writing? Those are all signs to help you identify someone with IDD. Is there a lack of appreciation for consequences or the situation? Do they not understand the seriousness of the situation, or do they not understand what the consequences are, or are they easily persuaded by others or eager to please? Do they not seem like they're working off of what they think is best for them as opposed to what you're telling them? Inappropriate behavior, this is things like other nonverbal cues. Are they smiling inappropriately, having issues with personal space, inappropriate facial expressions? Those are some other ways that are easy that you can identify ID without just coming out and asking, because sometimes even if you do ask, you will not get an accurate answer. And then another issue is communication. Just some quick tips for attorneys. So make sure you try to use simple wording, no complex terms or legalese. For the attorneys out there, we all know legalese is hard even for attorneys sometimes to understand, and let alone someone who's dealing with a cognitive disability. So try to make your arguments and your information as approachable and easily understood as possible. Usually it's recommended at about a 6th grade level is good to ensure understanding. Always ask open-ended questions. Don't ask yes/no questions or leading questions, because people with intellectual and developmental disabilities are very easily led, and if they feel like you're looking for a specific answer, they will give it to you even if it's not the answer that's most accurate. And also yes/no questions, for obvious reasons, don't really get across an understanding that the client needs to have. And a good tip to ensure understanding is to ask the client to repeat back what you meant. What did you just say to them? Can they explain what this means, to ensure that they are understanding what you're saying? Some other tips: be flexible and understand the client's needs. As Elizabeth alluded to, we understand that attorneys are very, very busy, especially public defenders have very, very large dockets and are completely understaffed most of the time. So we understand that, but I think it's important for attorneys to also understand that their client and their family might have more needs. The client may need some more time during an interview just to really get a sense of understanding of the issue. Their families may want to be more involved, as Elizabeth alluded to. Obviously, that brings up confidentiality concerns, but I think you have to assess that on a case-by-case basis. The case may take longer just generally because you have additional issues to be litigated if you have competency concerns, or if you end up going with an insanity defense or things of that nature. The case may take longer than a traditional case. Also, ADA accommodations. Each courthouse should have an ADA coordinator to help with needed accommodations. So if your client needs accommodations, so things like taking periodic breaks, allowing for videotape testimony or video conferencing. Some jurisdictions allow that, some do not. Using alternative text or note takers, alternative seating arrangements or modified schedules. These are just some of the accommodations that you can try to ask for or work with your local courthouse to get. Again, some of this is in the judge's discretion, so it would be important to argue really why this is so important to ensure that your client has fully gotten their due process and understands the trial that's going on against them or the proceedings against them if you're not at the trial level. And then do your due diligence. Once a disability is identified, learn more. Try to get an understanding of the disability. You might not think that it's relevant to the defense, but I think that it's always relevant that your client has this sort of disability, and it always impacts their behavior. NCCJD is one resource. We're here to help attorneys to understand disability and help clients get the best and help them get their best outcomes for their clients. So just remember that we're here, and one of the things we do is really explain to attorneys what they need to understand. So then some tips for families and clients, the other side of the coin. I think this is just really about understanding both sides and how both sides need to have some understanding. If you or your family member has some sort of cognitive disability, let your attorney know. If they don't necessarily, it will make the process go a lot more smoothly if they're aware of the disability and they can work off an assumption that the disability exists and get the required information and paperwork and documentation, as opposed to having to identify originally on top of it, and then you run the risk of them not identifying it and not finding out. Let your attorney what would help you make the process easier or more understandable. If you or your loved one is working with an attorney and they're saying something that you just don't understand, make sure that you're not just nodding your head and agreeing with them. Make sure that you voice, you know, I don't understand this. Is there something that we can do to make this easier? Let them know, because if they don't know, they cannot help you. Reach out to states protection and advocacy agencies. Many of them, while they don't do criminal representation, do advocate for people with disabilities in the criminal justice system. It depends on your state again. Reach out to NCCJD and other national organizations for assistance in speaking with your attorney and resources, and we can speak to your attorney if you would like us to, so that they really understand the situation and how it could have impacted the actions of the individual. One note on guardianship, Paul was under conservatorship, which is also the same thing as guardianship most of the time. It often does not solve one's criminal charges. So as you saw in Paul's case, he was under guardianship and he still ended up charged with a crime with felonies and going through the legal system. So don't think that having your loved one under guardianship will automatically solve the issues of their case or prevent them from having charges brought against them, because that's not necessarily the case. And guardianship has a lot of unintended consequences, and consequences that are unrelated to the criminal justice system. So just think twice, reach out to disability advocacy organizations like the ARC, or talk to your attorney before you take this step, just so you know your options and you know that guardianship just for the sake of avoiding criminal charges is probably not always the best option. And know that your attorney, whether a public defender or a private attorney, is most often doing all that they can. As Elizabeth said, the vast majority of attorneys out there really are working as hard as they can in your best interest as a family member. But you have to understand their limitations as well. They are sometimes constrained by the criminal justice system, by what the laws allow them. And that's why they're there, is to tell you this is the law and we have to work within it. But sometimes that's not always, it doesn't always feel like that's the best option, but it's the way that the system works, and you have to work within it as well as they do. Your lawyer is your advocate. They're in the best position to help you as you make your way through the criminal justice system. They know the local laws. They know the local, as Steve said in his presentation, having a local attorney especially, they know the courts and the judges, and all of that is extremely helpful when you're moving through the system. And finally, some of our resources that we offer for people, families, and attorneys alike. On our website, we have a variety of resources. So we have other webinars such as this on all kinds of issues ranging from sex offenders, people with IDD, juvenile justice, victimization and bullying. We also have a variety of white papers on similar issues. And then most relevant is you will find the Working with a Criminal Defense Lawyer fact sheet that Elizabeth created for us and had as part of her presentation today on our website, as well as a fact sheet for attorneys specifically with some more detailed information and some more tips and tricks for attorneys who are representing clients with IDD. So with that being said, I am going to turn it over to questions, but before I do, so please email me all of your questions. Now, put them in the Q&A box or email or the chat box, and I'll make sure that Elizabeth and Steve or myself answer them. So our next webinar will actually be talking about mental health courts, as Elizabeth alluded to. We will be having a sort of a debate on the pros and cons on the role of mental health courts for people with IDD, and just generally how it works. That webinar will be on July 28th, 2016, and you can register at the link on the PowerPoint. We will have this PowerPoint as well as the fully recorded webinar and the transcript on our website later this week for you or early next week, and also a link to the register for our next webinar as well. You can also on our website sign up to receive email alerts and our free quarterly newsletter, the NCCJD Bulletin. As I already said, you can use our information and referral or technical assistance services and refer others. We help both suspects and offenders and victims. with IDD who are going through the criminal justice system. Please, if you have a story, if you need assistance, contact us. We're also just trying to raise general awareness. And then let us know if you have a resource in your state or you know of a law in your state that's specific. We do have a database on our website that's state by state, and we would love to include your resources. So here are some questions. So the first question we have is more of a comment for Elizabeth, and it's from a retired police officer, Michael Sullivan, who is also on our National Advisory Committee. And he just wants to say that as a retired police officer, can't reinforce the point of enough that Elizabeth Kelley makes about the rights of the person arrested. Don't talk to a police officer without a lawyer present. Don't talk to the DA. Statements that you think are innocent could end up becoming an admission. That's very true, so thank you. So Teresa Parks has a question on guardianship, and I would defer probably to Elizabeth on this. Does the legally appointed guardian have a role when the individual with IDD encounters the criminal justice system?
I'm not the best person to answer this, actually, and I really haven't had that many circumstances where this has been an issue. I do know that sometimes family members feel it wise for the accused to be represented by counsel and for the parents to be represented by counsel in order to avoid any conflict. But my expertise is basically criminal defense, and unfortunately, like many criminal defense lawyers, I don't know a lot about guardianship, but it's one of the things I should learn more about.
So I should say on that note that one of the research projects that NCCJD is currently working on is examining this intersection between guardianship and criminal justice, and whether being under guardianship really does affect these things. So we had another question, or I guess comment about that as well, that although guardianship may not be the best option, it can also provide someone with legal standing to help advocate for someone needing a certain level of support. I guess this is jurisdiction specific. In the cases that we've seen, it actually hasn't really helped a lot in helping parents, especially, I guess those are the cases we've seen, helped them advocate anymore. They're not really given any more standing to advocate than they would have been not guardians, other than sometimes the attorney will defer to them more. However, when it comes to the justice system as a whole and what we've seen, it hasn't made a whole lot of difference. But again, that might be jurisdiction specific. So another question we've had is, and I'm not sure which one of you would like to take this one. When schools call police or involve a school resource officer over a behavioral incident involving a student with a disability, does the parent have the right to be notified? Elizabeth, is this jurisdiction specific as well?
I think it would be, but more often than not, if someone is in trouble in a school setting, that person is a minor. So as juveniles, yes, the full panoply of rights should be extended to them, including, but not limited to, having a parent present.
Okay, great.
Can you hear me? Can you hear me, Ashley?
Yes.
I just want to add, as a special ed teacher, what you're describing would typically be characterized, if that person has an IEP, would be characterized as a behavioral emergency. And yes, absolutely, within 24 hours, parents have to be notified of a behavioral emergency. And Paul's case, says more than often, they decided, well, we don't want to restrain Paul. They kind of became hostile to Paul's need package, so they started deferring to the school resource officer, and that's when he started getting this kind of a bad reputation with the local police force, which was mixed, because there are a lot of local police that were very understanding and well-trained and dealt with him just spot on appropriately. But there were a few I want to say, what macho cowboy kind of thing, where you're not going to fight me. Well, you're going to fight me. You're going to feel the full force of justice here. I mean, it really became a fight or flight standoff because you had cops being asked to play the role of a social worker or behavioral therapy aide.
Elizabeth, we can't hear you.
Can you hear me?
I could. Try to unmute yourself again.
How's that?
There we go.
Beautiful. We touched a little bit about police response, and I was glad to hear that Mr. Sullivan is on the call. An increasing trend across this country, a wonderful, welcome, and needed trend across this country is CIT training, that is to say, crisis intervention training offered to local officers. And although the bulk of calls that these trained officers respond to usually involve people with mental illness, certainly an officer could have been called to a situation like Paul was enmeshed in and probably handled it much more sensitively. But CIT training, very briefly, is very thorough education of law enforcement officers to show that traditional police tactics are not necessarily effective, indeed might be counterproductive with people who have mental disabilities. And officers are taught, for instance, not to wear uniforms, not to brandish a weapon, to try as much as possible to de-escalate the situation and try to divert the person into help that person needs, not necessarily the criminal justice system.
Elizabeth, it's great that you bring that up. We've actually been working with CIT nationwide to bring some more information on intellectual and developmental disabilities into the fold with that training. And then, of course, NCCJD does our Pathways to Justice training, which trains law enforcement, attorneys, and victim services providers together in an interdisciplinary model on intellectual and developmental disabilities in the criminal justice system. But training is very important, yes. So we have a couple more questions since we have some time. How can a self-advocate and their supporters educate their lawyers about IDD? Are they generally, do you feel, Elizabeth, open to it? Are there ways to bring that into the conversation in your experience that is helpful and productive?
Well, it depends. First and foremost, let me say I am proud to be a lawyer and I love practicing law. That being said, like any profession, we have some people who are a bit more hardworking than others and a bit more open to new information than others. Some attorneys are very receptive to all kinds of information that a family gives, and some not so much. But in particular, if you go back to that family guide, one of the things I point out is that the family can play a crucial role in giving the lawyer documentation, names of people to interview, some insight as to what the accused's daily life is like. And that should make the lawyer a more effective, more credible advocate on behalf of the accused. Understand that you can't drown your lawyer in paperwork, but I always tell families I'd rather have too much information than not enough. I can filter out what might not be relevant, what might not be persuasive or helpful to the court. But we as criminal defense lawyers, if we care, and I think if we're good, we represent our clients as the whole person. And for a person with a mental disability, this is part of who they are. And we need to bring that before the district attorney, before the prosecutor, before the court, in order to make sure that our client is treated as fairly as possible given the circumstances.
Great, thank you. So the last question is for Steve. So Steve, what advice would you give to a self-advocate and or their family when they're navigating the criminal justice system?
Well, once you recover from the shock that your loved one who behaves impulsively, you know that, and you've probably spent their lifetime apologizing or forcing them to apologize for things that offend other people, and now somebody is actually taking this to the next level. That was hard to overcome, but seek out resources, as you mentioned, advocacy groups. Like I say, the Autism Society of America was especially helpful for us and really gave us a lot of resources to go with. Eventually, the forensic psychologist that we used was recommended to us by the Autism Society. But that's just, one local resource that came through. I would certainly call the NCCJD, but I do want, before I forget, I want to affirm what Elizabeth said about the media. The media is a crapshoot. As a teacher, I'd always have students talking to me, well, I'm being cyberbullied, and I really had no experience with it until I put this out, Paul's case out there, and the R word came up. He deserves it. What are we supposed to do? Let this R word person just do whatever he wants. Just really, something else alluded to is that people are afraid of people with disabilities, so they really don't know how to deal with it. What I learned as a special ed teacher is that everybody will eventually be disabled. So I think it is a latent fear in if you live long enough, you will be disabled at some point. And I think it's a latent fear in everybody's back of their mind. So, to get back to your question, you got to remain calm and try to understand the whole mentality going on here and not take it personally, and try to keep a cool head about it. There were some times where I just kind of wanted to reach through a computer screen and punch somebody in the pie hole, and that is not going to do you any good, and it's just going to be affirming, oh, hey, look, you see, they're all on edge like that Sandy Hook kid, see? And that's not where we want to go. But I would calmly search for the resources that are available locally, but I would start locally and try to build a local support and not necessarily just kind of put your loved one's private conflict out there in the media. That being said, I have to say that our media campaign, probably officially was of no consequence, but I think it was starting to have an impact locally. I would try to keep it local, try to keep it calm, and try to keep it on a level to where you can put the toothpaste back in the tube. One dilemma I have right now, because I made it sort of a national or actually an international thing, is putting the toothpaste back in the tube. How do I protect Paul's privacy now? How do we kind of seek normalcy since he's, we've had this 15 minutes of cause celeb. Actually, Paul couldn't care less. So for his part, it's no big deal. And then we're sort of recovering. But I would seek out local advocacy groups first and foremost, because they may know a lawyer that's already dialed in. Our lawyer Tom Worthington is now seeking to kind of make this one of his specialties is criminal justice for people with special needs.
That's great. One last question for you, Steve. Is Paul getting any training or education on what to do now if he encounters police?
Well, not specific on that. What they're working on is a general, one of his triggers is non-preferred activities or tasks. So to escape that, he learned to become aggressive and loud and, oh, well, okay, we'll give you a different task. You don't have to do that. Oh, your parents will come pick you up. What they've been working on at Lake Mary, and what has always been one of his triggers, are alarms. And now he doesn't have to go through earthquake drills like he does here in California, but they do have tornado drills there. And so that was like a new variable being thrown at him. And he's had mixed success, but he's getting better and better. But specifically for police, that's actually a great question, is how to respond appropriate to the police. And I will bring that up to his case manager, but nothing specific to that. He's only been there for about 3 months anyway, though.
Okay, great. Well, unless anyone has any other questions, I don't see any. So I thank you all again for being here, and I hope you enjoyed. And don't forget to join us on July 28th for our next webinar. And thank you again to Elizabeth and Steve for being here and providing us with this wonderful information. We appreciate it. Have a good afternoon.